Hello, everyone, and welcome to Uncivil Law. For today's case, we have a situation where the police are arresting someone for taking photographs of an ongoing prostitution sting. This is the case of William Lung versus the city of Rockford, Illinois. In this case, Mr. Lung was taking photographs, and the police didn't like it, and so they chased him down. But we're going to figure out whether or not the police had the authority to arrest him, so let's read on. Lund was a reporter and an administrator for the Rockford Scanner, a news organization that reports on notable events in the Rockford area. On May the 25th, 2015, he heard, by way of the police scanner, which presumably is how his newspaper got his name, a number of traffic stops in a midtown district of Rockford. Because he does not have a driver's license, outstanding, he rode a motorized bicycle to the area where he began taking photographs. He quickly surmised that the police were operating a prostitution sting operation. After about 10 to 15 minutes of photographing the scene, he retreated to an alley. In the meantime, a surveillance officer at the scene of the sting noticed Lund riding his motorized bicycle and taking photographs, and subsequently radioed other members of the sting team to report it. One of the undercover officers posing as a prostitute also noticed Lund and called another officer, Officer Sean Welsh, on his cell phone and told him she was concerned about a man who was on a motorized bike who was taking pictures of her. Officer Welsh and Officer Timothy Campbell knew of Lund and were familiar with some of his previous anti-police speech. Officer Welsh knew Lund was a reporter for the Rockford Scanner. Officers Campbell and Welsh found Lund in the alley, and Campbell informed Lund that he needed to move on. Lund asked if he was breaking any laws, and Campbell informed him he was not, but if he did not leave as requested, his continuing presence would constitute obstruction of police detail and they would arrest him. Personally, I think at this point he should have just stood there and let them arrest him. If he's in an alley, far away from what's going on, he's not interfering with anything. That would be an easier case. But that's not what happened. Lund started the engine of his bicycle, and as he rode away, he called out to the undercover officers loudly over the noise of the engine. "Goodbye, officers. Goodbye, officers." At that moment, Welsh and Campbell made the decision to arrest Lund for obstructing a police investigation. He wasn't doing any of those things, but yeah. They had concerns that because of his previous animus towards the Rockford police, he might post pictures on social media while the sting operation was still ongoing, which they assumed would create a danger for the undercover officers who were unarmed in a high crime area. Well, people have a right to take notice of things that are happening in plain view, in public. The laws that the police love so much, go both ways. They're in plain view. There's no reasonable expectation of privacy. So if this person wants to take photographs of something that's happening in plain view, no expectation of privacy, then, it should be perfectly fine. He's not like right up in the scene. He's not preventing the police from doing anything. He's not, doing anything. And even if he was actively alerting people, like on a bullhorn, hey, those are police officers and stuff, he'd be exercising free speech. We've seen those kind of cases where like one motorist will flash their lights and to warn that like a cop is nearby. And we've seen the cops pull that person over for interfering. We've seen those cases be thrown out because of those free speech too. So like if you want to alert people, that's fine. You can't, actively interfere with them, and that wasn't what he's doing. He's far enough away. But the cops, have a bug up their butt, so they're not gonna let this go by. After a block of following Lund, the officer stopped and then arrested him for driving the wrong way on a one-way street, operating a vehicle without insurance, resisting or operating a police officer, felony aggravated driving on a revoked license, and operating a motor vehicle license without a valid driver's license. So yeah, so he had a license. He didn't have a license, which is the reason he was using this motorized bike. But then the question is, does that actually qualify as a motor vehicle? So we have to figure that out. Under Illinois law, a motorized bicycle is considered a motor vehicle if it can propel a 170-pound person more than 20 miles an hour or more on a level surface. So we have a definition. Conveniently, Lund weighs approximately 170 pounds, and the officers reported that they were following directly behind Lund, matching his speed at 24 miles an hour. So presumably because of this, like all those scooters that Uber and Lyft leave everywhere, although not as much right now because, reasons, that's one of the reasons they can't go too fast, so they don't qualify as motor vehicles. But yeah. In the district court, Lund argued that he could only reach a maximum of 20 miles an hour. The district court held that no reasonable juror could conclude the defendants did not have a basis for believing, to a reasonable degree of certainty, the plaintiff vehicle was traveling fast enough to violate the law. So yeah, it's like, did you even have probable cause? Yeah, you kind of did, because like it seemed to be going that fast. Yeah, okay, that's okay. That's the way the law reads. On appeal, Lund appears to have been abandoned arguments about a bicycle's status as a motor vehicle under Illinois law. Following the arrest, Officer Eddie Torrance pulled together a list of people who were arrested during the sting and gave it to his lieutenant. From there, someone else, who has not been identified, used the list to prepare a press release. Following the arrest, Officer Eddie Torrance put together a list of all the people who were arrested during the sting and gave it to his lieutenant. From there, someone else, who has not been identified, used the list to prepare a press release, which became the source of news stories that listed Lund's name as an arrestee during the prosecution sting. So that's a nice little burn there, yeah. Torrance testified that publishing this type of arrest information is a form of public shaming the department uses to dissuade people from soliciting prostitutes, or from taking pictures, or from being a pain in the butt as far as the police are concerned, yes. Lund has sued the officers and the city of Rockford for false arrest, unreasonable search and seizure, failure to intervene, First Amendment retaliation, conspiracy, and malicious prosecution, all under 1983, and for malicious prosecution under Illinois law. Lund appeals only from the entry of summary judgment for the defendants with respect to two claims, the federal First Amendment claim and the malicious prosecution claim, decisions we review from First Steps. Lund claims the officers arrested him in retaliation for his speech and news-gathering activities protected by the First Amendment. Lund's concerns are not without basis. Nearly every authoring justice of the latest Supreme Court's opinion on retaliatory arrest acknowledges a risk that some police officers may exploit arrest power as a means of suppressing speech. You don't say, yeah. Even while expressing concerns about abuse of police power for retaliatory arrests, the Supreme Court answered the only question posed in this case. Does probable cause to make an arrest defeat a claim that the arrest was in retaliation for speech protected by the First Amendment? The answer the Supreme Court has held, just 39 days after the District Court entered its opinion in this case, is yes. The plaintiff presenting a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest. So yeah, there was this issue that the Supreme Court was trying to resolve and did resolve with exactly like these mixed motives kind of case. Right, so the police have purely lawful motives, it's cool. They have purely unlawful motives, it's uncool. What if they have a mixed motives? What if they have some lawful motives and some unlawful motives? And the one they went with was, as long as they have probable cause, it's okay. So, and this is the same thing for traffic stops in general. So this is the rule we use for traffic stop, it's the rules we use for all arrests now. So, if the police pull you over, regardless of whatever else might be going on in their head, as long as they have probable cause, you're committing some kind of crime, it's illegal. So we can't get into like the actual motives or anything. We just look to, did they have probable cause? And here, the same issue. It's like, okay, maybe they arrested him because of his First Amendment issue. Sounds plausible. Maybe they did because of this reason. Sounds plausible. But as long as they have probable cause, we don't care, because the Supreme Court said we're not supposed to care. That's the state of the law. So yeah. At the time of Lund's arrest, the officers had probable cause to arrest him for, at a minimum, driving a motorized vehicle the wrong way on a one-way street. Lund does not challenge this finding, therefore his claim for retaliatory arrest fails. They had a valid cause to arrest him at the time they arrested him. Lund, however, proposes that this case squeezes through a crack of an opening left open by the Supreme Court. The court described that opening as follows, so quoting the U.S. Supreme Court now. Although probable cause should generally defeat a retaliatory arrest claim, a narrow qualification is warranted for circumstances where officers have probable cause to make arrests, but typically exercise their discretion not to do so. In such cases, an unyielding requirement to show absence of probable cause could pose a risk that some police officers may exploit the arrest power as a means of suppressing speech. As an example, the Supreme Court majority described a hypothetical in which a police officer uses a jaywalking arrest to retaliate against a rabble-rouser complaining about police conduct when all other jaywalkers are almost never subject to arrest. Lund asserts that his arrest for driving a vehicle the wrong way down a one-way street was, in fact, retaliation for his protected First Amendment journalistic activity. But to make this argument, Lund would have to present objective evidence that he was arrested when others similarly situated were not engaged in the same sort of protected speech had not been. Again, quoting the U.S. Supreme Court case. So yeah, you'd have to present objective evidence that they are using this to target you. It's the kind of thing that they don't arrest for, or it's the kind of thing where they only arrest people who are engaged in protected reasons, but not unprotected reasons. So you have to show this kind of disparate treatment in fact. Supreme Court did leave open a door, but it's not a very wide one. So yeah, as a general rule, as long as they have some reason to arrest, it's going to work as far as probable cause goes. That language in Nivens implies that Lund would have to present objective evidence that the police rarely, if ever, arrest citizens who drive vehicles, or perhaps more specifically, motorized vehicles the wrong way down one-way streets. It is possible, however, that this case left open the possibility that Lund could demonstrate the evidence in some other way. The Supreme Court has required that a plaintiff present objective evidence that he was arrested when others similarly situated had not been engaged in the speech had not been. Regardless of how we interpret the requirements from the Supreme Court, however, Lund has not presented sufficient objective evidence of retaliation that will allow him to slip into this narrow exception to the rule, which dictates a probable cause to arrest defeats a retaliatory arrest claim. Lund has made no attempt to present objective evidence showing the police rarely make arrests for driving the wrong way down a one-way street, or that other similarly situated persons were not arrested and has not demonstrated the retaliation in some other way. Which is slightly unfair because, as the district court or this court was pointing out a little bit earlier in the opinion, like it was like 30 days after the district court that this Supreme Court case was decided. So it's a little bit unfair to say, well, you didn't meet the standard because you didn't know about it. But, that's the way it goes sometimes. You have to, you didn't know about it, but you're not going to get a chance. Yeah, that's the way it goes. We take no position as to whether Lund's behavior met the criteria for obstruction of justice, and we need not. The officer's reasonable belief that the Lund's activities were obstructing, or might come to obstruct their investigation, were sufficient to stop him and ask him to move along. Although First Amendment activity is generally protected, it loses its protection when it violates the law, and generally applicable laws, like those that prohibit interference with police investigation, do not offend the First Amendment simply because their enforcement against the press has incidental effects on the ability to gather important news. It is possible, of course, that based on Lund's activities, a court might conclude that no reasonable officer could have construed his activities as constituting obstruction. After all, reporters are free to take photos and videos of what they see in a public street, even if it involves police activity, citing cases to that proposition. Again, however, we note that we need not delve into this question. The officer had a clear right to stop, question him, and direct him to cease doing anything that placed the undercover officers in jeopardy. So the court here is being a little bit loose because the counterfactual didn't happen, right? So, yes, the police have the ability to ask you to stop doing things that interfere with it, but not if it prevents you from taking photographs. And he was just taking photographs. So, police can always talk to you. They can always ask you things. If he had refused and they arrested him, whether he'd have a claim then, in view of the Seventh Circuit case law, is more of an open question. But I think that, because it didn't happen, we don't need to raise those questions. Courts don't like answering questions on things that don't happen. It's like, we'll let the next panel on the next court figure that part out, right? So it's like, we'll only have to answer as much as we have to deal with, which I suppose is fair enough. We need not address the question of whether the officers had probable cause to arrest Lund for obstruction of justice, because whatever the officers reasonably believed about Lund's activities and whether those activities in fact constituted obstruction of justice did not matter in the end. Lund was not arrested until after his clear violation of the Illinois vehicular law, driving against the traffic pattern on a one-way street. And Lund has not argued in this court that they did not have probable cause to arrest him for the offense. Yeah, so they ultimately arrested you for something that was in fact violation of the law. So whatever their motivation might have been, at the time of arrest, they had probable cause. So, if they had arrested you sooner, maybe not. But at the time they actually arrested you, you were in fact breaking the law. So, there's that. As to the qualified immunity, as we have noted, the rule of the Supreme Court applies retroactively. If the plaintiff cannot plead and prove the absence of probable cause, the retaliatory arrest claim fails. But even if it did not apply retroactively, Lund still could not have prevailed, as the defendant officers were entitled to qualified immunity, because of course they are, because that's how QI works. We all know this so well. At the time of Lund's arrest, therefore, the Supreme Court has specifically stated that it never has recognized a First Amendment right to be free from retaliatory arrest that is supported by probable cause. This forecloses an argument that any officer would have understood the First Amendment preclude the arrest. In short, no matter how we apply the substantive ruling of the Supreme Court or look to the qualified immunity question presented in Retchi, Lund cannot prevail under qualified immunity. Yeah, so again, that is a problem, yes. As to malicious prosecution, under Illinois law, to succeed on malicious prosecution claim, a plaintiff must prove the commencement or continuance of an original criminal or civil judicial proceeding by a defendant, the termination of the proceeding in the favor, the absence of probable cause for such a proceeding, the presence of malice, and damages. Only the second of these issues is at issue here. Approximately 8 months after arrest, the attorney filed a motion to dismiss all charges. The same day, the state's attorney also filed a motion to dismiss the charges. In response, the court entered a bare nolle prosecuale, or order which simply states the case is dismissed on the motion of the order of the state attorney. For purposes of the prosecution action, the plaintiff has the burden to prove that the nolle pros was entered for reasons related to incident. Despite the bare order, the Lund argues the timing and circumstances surrounding the entry of the nolle pros order support a finding that the charges were dismissed because the government lacked a reasonable cause to proceed. Illinois law makes clear the burden is on the plaintiff to prove a favorable termination, and coincidence in timing on top of a bare use of the nolle pros order does not constitute the sort of proof which might compel an inference that there existed a lack of reasonable grounds to pursue the criminal prosecution. Lund has not met his burden to demonstrate that the nolle pros order, in this case, was a termination favorable to him, and thus the malicious prosecution claim fails. So that is the case of William Lund versus the city of Rockford, Illinois. In this case, we learn that Mr. Lund was taking photographs of an ongoing prostitution sting operation, and the police decided to arrest him. But at the time of arrest, he was, in fact, violating a law. He was operating a motor vehicle despite not having a license, and he was going the wrong way down a one-way street. So they were able to arrest him, and therefore they can't make the retaliatory arrest or malicious prosecution claims. So, unfortunately, there is no justice for Mr. Lund here, and next time I guess he'll just have to take a regular bicycle when he's conducting his surveillance operations, and that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. I appreciate your continued support. If you haven't already done so, please subscribe to this channel, and you can also support us financially by clicking the applaud button below. Thank you so much for your contributions to our channel. It helps our work grow. Until later, cheers and goodbye.